Okay, great. So I put myself first because I made the presentation, get it over with. So I will just get started with my 5 things to know about Evanston's Fair Housing Ordinance. So the first thing to know about this law is its purpose is to prevent discrimination against people with criminal records. It's right there in the text of law, which I just copied and pasted, but that is really the intent. There's a lot of details that I'm not going to talk about today. If you want to look it up, it is the Evanston City Code Title 5, Chapter 5. It's called the Fair Housing Ordinance, and you can take a look at it for yourselves and see what sorts of protections and prohibitions are built into it. I'm just going to talk about a narrow section of them today, but the whole law really is meant to try and prevent housing discrimination in this area. One thing that I always like to highlight is that people think criminal record and they think convictions or plea deals, but this law is special because it doesn't just protect people with convictions, but also any sort of interaction with the criminal legal system. So that involves expungements, deferrals, juvenile records, and arrests, and that's why I have a little hand with the sponge, because I think of that when I think of expungements, and then also the sealed records. So it really is a pretty broad, a law that offers a lot of broad protections. The second thing that I wanted to put on here is that it's just like a Cook County law. The Cook County law is called the Just Housing Amendment, and it's an amendment to the Cook County Human Rights Ordinance. And so that applies to all of Cook County, including Chicago and including Evanston. But the Evanston law is a little bit stronger in some ways. For example, there's a provision in the Evanston law that doesn't exist in the Cook County law that the city of Evanston can actually take legal action themselves if they notice that a certain landlord has a pattern or practice of behavior that violates this law. So they're pretty identical, which is great because the work that I do is mostly just housing amendment work, but it was very, very easy to learn this law because they were nearly identical. The next one is that landlords can't ask about criminal history right off the bat. So this is a little bit where we get into the nuts and bolts of this law. But 2 things that I want everyone to take away from this is that if landlords are asking anything about criminal history on the first application that you sent to them, that's a huge red flag. They shouldn't be doing that. That's why I have that check mark there, because sometimes there will be a box that says check here if you have any criminal history, and that should not be on that application. There's going to be a process that I'm going to talk about a little bit more in the next slide. But essentially what should happen is the landlord should take all of your information first. That includes pay stubs, other financial information, other landlord references. They need to evaluate that first, and then if the person seems like a good candidate based on that information, they need to tell them that they're pre-qualified, and then they'll do the background check. The background check can't come with the credit check or with everything else. The exceptions that I have on here are the sex offense registry or child sex offense residency requirements. Those are 2 carve-outs that are in both the JHA and this Evanston law. So everything that I talk about here, the protections wouldn't apply to folks who have those convictions on their records or those requirements on their records. There are also some really narrow federal exceptions that I just like to mention because federal law supersedes these local laws, but they're very, very narrow and they only apply if you are applying to federally funded public housing. In that case, I would say see a lawyer. My details are at the very, very end, but they're really narrow exceptions and I've never seen them in practice. So I made a little game board because I was trying to think of creative ways to conceptualize the way that this law should work. The first thing that should happen is landlords have to make certain disclosures before they accept your application fee. Some of those disclosures include information about this Fair Housing Ordinance. And then what has to happen is the application fee, the application itself, and then that pre-qualification, I think. Yep, my next slide. So we are here, pre-qualification. This is the step where the landlord tells the applicant that they're otherwise approved for the apartment, and then they're going to do the background check. So the background check has to come after all of those other steps have been taken. The next thing to know, the fourth thing to know, is that there's a 3-year look-back period for this law. So what that means is if you have a conviction that is older than 3 years, the landlord isn't supposed to consider it at all. So I have the 2020 calendar on there because we're in 2023, as hard as it is to believe, and anything that is older than 2020 should really not be considered. If it is considered, I have a slide on that later, but as just a blanket rule, landlords should not even be looking at that. And that includes, of course, landlords shouldn't be looking at arrests, convictions, drop charges, deferrals, expungements, anything that's not a conviction the landlord shouldn't be looking at, and then convictions that are older than 3 years they shouldn't be looking at. So again, we're back to the game board. I've just circled where we are in the process. And then the second part to the 3-year look-back period is that if you are within those 3 years, if you do have a conviction from 2020 or later, the landlord can consider it, but they can't reject you outright. So what that means is that they have to take a look at what the conviction is and do what's called an individualized assessment. I think that is that's my next game board piece. The individualized assessment has to be in writing, and it has to make a connection between the conviction and why this person, because of that conviction, poses a demonstrable risk to the rest of either the apartment property itself or their neighbors. So the main takeaway here is that landlords can consider convictions from within the last 3 years, but they can't just decide to not rent to someone because they have a conviction. They have to give a reason why. The fifth thing to know about this law is that there are legal remedies. I would say talk to UPLC, talk to me. Even though I'm based in Uptown, we do take these kinds of cases throughout Cook County. There are a few options. The Evanston Ordinance gives individuals a private right of action, so you can sue in a court of competent jurisdiction, which just basically means any court that is within the Evanston jurisdiction. You can also file a complaint with the Cook County Commission on Human Rights, just like you could if you were anywhere in Cook County. And there are pros and cons to both, but overall, some things that you could be looking at as a remedy are housing. So sometimes this kind of advocacy or taking legal action results in the landlord giving you the housing that you were initially denied. You can also sometimes get a settlement fee, and then you can also get either Cook County or just a settlement agreement between the landlord and you for the landlord to engage in training or compliance or monitoring. So the idea is that the landlord wouldn't be able to do it again. So these are all changes that can come from taking legal action. But of course, the first step to being able to do that is knowing your rights. Excuse me. So that's why we have this presentation here today. And then my final slide is just my information. I'm going to leave it up there for a second. But again, anyone who even has questions about whether they faced housing discrimination, please do contact me. We can give you a lot more details and resources if we know what's going on. So please reach out and give us a call. And that's all I have for you today.